We've previously addressed the issue concerning court custody proceedings and the long-term effects that that can have on children and families. And we've always discussed that it's better for the parents to try to resolve those issues as opposed to that being resolved by an individual in a black robe who knows very little about the family. In fact, they just are taking a snapshot in time of what's going on with your family, and then they have to make a decision. So we've encouraged therapy, meaningful conversation, keeping the communication lines open, because what we want is the parents to resolve it and court to be a last resort. But what happens if you do go to court? And now a judge has to make that determination. Well, I want to address that because there's certain misconceptions concerning that, and I want to sort of demystify the process and talk about reality, what's going to happen in your case. If the judge gets a court proceeding involving custody or parenting time, what they're going to do is they're going to appoint an attorney for the child or the children. Now, it's not mandatory, and they're not obligated to do that, and in limited circumstances, they won't. But generally, they will do that. The attorney that they will appoint was formerly known as a law guardian, and that's what they were. They were guardians for the children. They would meet with the children, they would speak to the parents, they would file reports, and ultimately, they would report back to the court what was in the best interest of the children. But as of a change in law and in policy as of 8 or 9 years ago, and that a law and procedure that maybe some parents don't know about, that title and that role has changed. They are now known as attorneys for the children. And although they do some of the things and some of the obligations that the law guardians used to, including filing the reports and reporting to the court, meeting with the children, there are significant differences. Number one, they are exactly that, attorney for the child. And therefore, the child has all the rights and obligations when they have an attorney that any other individual would have, including an attorney-client privilege. Okay. Number two is that the attorney for the child must advocate what the child wants, what the child's preference is, even if the attorney for the child doesn't agree, and even if the attorney for the child thinks that it is not in the child's best interest. This is a significant departure from what we used to have. That is their role now. There's only two conditions in which they do not have to do that. One, they firmly believe that the child does not have the capacity to have a voluntary informed decision, maybe because of age or some infirmity or some other issue. Or two, they believe that the child's preference in this case would lead to imminent serious danger or harm to the child. If that's the case, then the attorney for the child can substitute their judgment as opposed to the child. But absent those conditions, they cannot. And so, this is the current law, and parents have to know this. They have to process what this actually means. For the first time, we're talking about something other than best interest. Yes, it's true that the courts are still going to rely on the best interest standard, but now another factor, that being introduced by the attorney for the child, as to the child's preference, which may not be their best interest, is into the formula as to what a court will do to evaluate the situation. Secondly, parents are sometimes overconfident on what they think their child is going to say. I've been involved in many court proceedings, and many parents are shocked when they hear what their child's preference is. And so they may think, well, this is a good rule because I know what my child is going to say. That is not always the case, and they don't want to be surprised at the last minute when they're in front of the judge. 3, teenagers. Sort of all bets are off when it comes to teenagers, and I understand what the teenagers are dealing with. They feel like their childhood, their adolescence is being taken away from them because their parents are splitting. And what they want most, in most of the cases, is to remain in the home, in their room, near their friends and their activities and their school. And I've had many circumstances where the child will actually say they want to stay with the parent who gets the marital home as opposed to the parent that they actually have a better relationship with. And so you'll see a lot of this infighting in custody proceedings on which parent is going to get the marital home because there is this issue of where the children want to be. Last point, and I hear this all the time. At what age must the court follow the child's preference? Is it 14? Is it 15? Is it 16? Well, there is no magical age, and there is no such rule. In fact, The child's preference is not dispositive of what the court has to do. The court will make up its own mind based on the factors before it. But the court is also realistic. They understand that telling a 16-year-old or 17-year-old that they have to live with a parent that they do not want to live with poses its own problems and enforcement proceedings. So this was a talk not so much about how intrusive the whole procedure is, but more about the parents communicating and having the option to make a determination about what's to happen to the children before it's out of their control.